now that the Constitutional Convention has sent this document to the states, and now that it's been ratified, approved by the states, we're going to spend this lecture just looking at an overview, a bird's eye view of this new document called the Constitution, and the first 10 amendments to this new document called the Bill of Rights. The Constitution itself, after the preamble, is divided into 7 articles. Now don't get confused, this has nothing to do with the Articles of Confederation. The articles is just another word for chapters or sections. So it's divided into 7 articles. Article 1 is by far the longest and was considered by those at the Constitutional Convention to be the most important because it deals with Congress. Again, the expectation in this new government is that the center of power will be Congress. That's hard for us to appreciate today because we think of the president as perhaps having more power. But that is something that's a dynamic that's only happened in the last, say, 60 or 70 years. We'll talk about that a little later on in the course. But for the first 150 years or so of our country's history, Congress really was the center of power, and it was intended to be so. So Article 1 talks about Congress, and as we mentioned, the Great Compromise created what was called a bicameral or 2-house Congress. There is a House of Representatives and a Senate. Article 1 talked about how these men were elected, what their qualifications should be, what their pay should be, and how those houses should run themselves. Okay, what were the rules within each and individual house? It also talked about, very importantly, in Article 1, Section 8, the powers of Congress. It listed very specifically several powers that Congress had. Again, the desire here is to fix some of the problems that the Articles of Confederation had created, so you shouldn't be surprised to find that the first power enumerated in Article 1, Section 8 is the power to lay and collect taxes. If you remember the fact that the Articles of Confederation, the Congress there could not collect taxes, was a huge issue. It also, in Article 1, talks about what Congress cannot do. It's very specific in laying out things that Congress can't do. Article 2 talks about the president. It talks about how he's elected, what his qualifications must be, and it states the oath of office. It also talks about his powers and his relationship with Congress. And it talks about how a president is impeached. Article 3 talks about the judicial branch. It talks about the Supreme Court and lower courts. It talks about the powers of judges, and it defines treason. And if you look at the document itself, the Constitution, you will see decreasing space or size for each of these different articles. Article 1, very long. Article 2, about half the size of Article 1. Article 3, the judicial branch, just a paragraph. It really was not seen to be that important a branch of government. There was to be separation of powers. We needed to have a separate judicial branch, but it was never seen as being as important as it is today. Today, the judicial branch has significant power in the American political process, and I think that's something that if the Founding Fathers were reawakened would surprise them. Well, the first 3 articles of the Constitution lay out the framework of our government, but there's some more that's there. Article 4 talks about relations between the states. And what that means is that it talks about how laws in one state need to be respected by laws in other states. Okay, this is something that perhaps plays an important role today in things like marriage, gay marriage laws. If certain states, if you are married in Massachusetts, for example, and you move to a state where gay marriage isn't allowed, are you still married? You know, does the state of Kansas, for example, need to accept that? And the Constitution would say, yes, it does. Article 5 talks about how the Constitution can be amended. That means changed. If you remember under the Articles of Confederation, unanimous consent was required to amend the Articles. The people of the Constitutional Convention understood that that was a very untenable situation. It was impossible to ever amend the Articles, and this Constitution needed to be more flexible. Again, this is a document where they left many questions unanswered, and so there are going to need to be changes. There are 2 ways you can amend the Constitution. It can begin either amongst the states themselves if 2/3 of the states propose an amendment, or it can begin in Congress if 2/3 of Congress proposes an amendment, and then this amendment needs to be ratified, approved by 3/4 of the states. Article 6 simply states that the Constitution, is the supreme law of the land. What this means is that if there is ever a conflict between a national law under the Constitution and a state law, that the national law is supreme. Okay, the Constitution is the supreme law of the land. And then Article 7 talked about how the Constitution would be ratified. It talked about the fact that it would be sent out to the states, that these states would hold special conventions, and that when 9 states approved this new Constitution, it would go into effect. That happened, but it happened before some significant states had bought in. So it was a good thing that the 10th state, Virginia, did come in, because this country would never have functioned well in the early years if some big states like Virginia and New York and Pennsylvania hadn't bought in. Well, that's the Constitution in and of itself. But almost immediately, additions were made, changes were made, amendments. The first 10 called the Bill of Rights, and I want to walk you through those as well. First, I want to talk about why a Bill of Rights. During that ratification debate, when the Federalist Papers are being published and put out there, and there's these conventions being held, people in favor of the Constitution called themselves Federalists, Federalist Papers. People opposed to it had the unfortunate name of Anti-Federalists. They really didn't stand for anything, they just didn't want this Constitution. The Federalists understood the concerns that the Anti-Federalists had, which was simply that this new government was too powerful, that there was concern that we would go back to the tyrannies of England, but they didn't want to go back to ground zero and start over. So a deal was made, a sort of a under-the-table kind of deal, where if the Anti-Federalists would jump on board and support this new Constitution and get it ratified, then the Federalists would agree that when Congress first met to consider and put into effect some amendments to meet the concerns of these Anti-Federalists. And it's those concerns that wind up being the Bill of Rights. The Federalists are true to their word. When Congress begins to meet in 1789, they receive from the states over 200 proposed amendments or changes to the Constitution. Now, that's a lot to go through, but fortunately, most of them were the same. Every state said something about guaranteeing freedom of religion, for example. So Congress is able to work on this, and the House of Representatives narrows it down to 17. That goes to the Senate, and they narrow it down to 12. Those 12 go out to the states, and only 10 of those 12 are actually approved by 3/4 of the states, and those 10 changes simply become known as the Bill of Rights, or our first 10 amendments. So let's look at those real quick. The First Amendment, probably the one we're most familiar with, everybody can quote it: freedom of speech, religion, press, assembly, and petition. Okay? Also, and we'll talk about the First Amendment specifically, but there's also a freedom of association that's been read into that. These are the basic human freedoms, and the concern was of the Founding Fathers, especially those that thought the new government had too much power, was that these rights could be taken away. The Second Amendment deals with the right to bear arms. There was a concern, again, that the Founding Fathers had, that this new government would be able to take away weapons. People wanted to own their own weapons. You needed a gun back then to defend your homes, frankly, to go hunting. Every American had one, and the fear that the government would somehow eliminate your opportunities to own weapons was why the Second Amendment was passed. The Third Amendment, probably one we know less about, this has to do with quartering of soldiers. Something that happened in colonial times was that frequently the English government would assign troops to a given town or city, and the burden was on that city or town or the individual citizens within that town to actually support those soldiers. That is to say, you could put them up in the local hotel for free, or let them sleep in your guest house or whatever, or the town itself could raise money and pay the rent, but it was up to the town to provide the quartering, the room and board for those soldiers. This was something that colonists hated. They wanted to make sure our government never did that. So the Third Amendment says no quartering. The Fourth Amendment guarantees us many things, but the most important of which is freedom from unreasonable searches and seizures. And again, this is something that goes back in colonial history to documents called writs of assistance. During the time when the colonies were under English rule, there were laws about trade that the colonies didn't like. We loved to smuggle. We were supposed to trade only with England, but we could make so much more money smuggling things in and out of the French West Indies or with Spain or something like that. So we loved to smuggle. And England didn't like that, and so they had what were called writs of assistance, which were unlimited search warrants. They were simply search warrants that a customs inspector allowed him to search anything at any time for any product. And the colonists hated it. So the colonists, the anti-federalists now, made sure that our new government was not allowed to do these writs of assistance, that we were protected from these unreasonable searches and seizures. The Fifth Amendment, one that's very common in the legal process, guarantees you due process of law. That's a phrase that simply means the government has to follow its own rules. If the government has certain rules or protocols down for how trials are held, things like that, it has to follow its own rules. Also guarantees you against no double jeopardy. In other words, you cannot be tried twice for the same crime. If you are found innocent of a crime and more evidence turns up later, the government can't simply keep putting you on trial until they get a verdict they want. And you cannot be forced to testify against yourself, what's called no self-incrimination. You'll see this frequently, high-profile crimes where people take the fifth. That's what they mean. I can't be forced to testify against myself because then either I have to confess to the crime or I have to perjure myself by lying. So you can't make me do either one of those. Sixth Amendment, also relating to legal procedures, had to do with guaranteeing you a speedy and public trial. It also guaranteed you the right to confront and call witnesses, and it guarantees you a right to counsel. Now, pause here for a second. This is one that we'll talk more about later because it guarantees you, for example, the right to counsel. It doesn't mean you get to have counsel. It just means that you can have counsel if you can afford one. One of the things we'll talk about when we get to the 1960s in this class, talking about civil rights, is that what is the obligation of the government to provide an attorney for you if you can't afford one? That's not originally the intent of the amendment. It simply is that if you want an attorney, you can have one. Seventh Amendment guarantees you a jury trial in certain civil cases. Not a criminal case, not a crime where it's you against the state, but a civil case. You're suing somebody. If the dollar amount is a certain value, you're allowed to have a jury trial there. Eighth Amendment. Again, one that's very common, especially today in death penalty cases, because the Eighth Amendment guarantees you against any cruel and unusual punishment. The Ninth and Tenth Amendments are the ones that seem a little out of sorts. The Ninth Amendment guarantees other rights to the people. Here's what was meant by this. The Anti-Federalists believed that in making this list of amendments, what the powerful government might do is argue that anything that's not on the list, you're not guaranteed. Think of all the rights you have. You have the right to get whatever job you want. You have the right to sell your house, the right to own property, the right to have a kitten, whatever. You have all these rights. But if it's not listed in here, how are you guaranteed those rights? Maybe the government could come back and say, well, nowhere in the first 8 amendments does it say anything about you having the right to own a kitten, therefore anybody who owns a kitten goes to jail. The Ninth Amendment says that there are other rights that the people have that are simply assumed for them to have. Far more important than owning a kitten, but things like being able to travel, being able to get an education, etc. The 10th Amendment is similar to that. It guarantees powers to the states. And what the 10th Amendment says is this: if a given power is not specifically given to Congress in Article 1, Section 8, where the powers of Congress are given, or specifically denied to the states in Article 1, Section 9, then those powers belong to the states. In other words, there are some powers that it says Congress can only do this. And there are others where it says states cannot do that. If it's not in that list, the state gets to do it. This is why today most of your day-to-day life is actually run by the state government. Okay, it sets things like education requirements, marriage laws, drinking tobacco laws, driving laws, etc. Things that kind of your day-to-day, out the door, going to work kind of life are run by the states. We understood that the federal government had to do certain things. We understood that the states shouldn't do certain things, like coin their own money, for example. What good would that be if we had 50 different kinds of currency? But if it wasn't in that list, the 10th Amendment guarantees that it belongs to the states.